Hello and welcome to this webinar, which will focus on the recent and forthcoming immigration developments arising from Brexit. My name is Wadley. I'm a partner at Gately Legal, where I specialise in both employment and immigration law. I help organisations move their workforce around the world, and recently have had a real focus on helping organisations and businesses review and update workforce planning strategies in light of the inevitable changes to the UK immigration regime after Brexit. This is particularly relevant to the sports and recreational sector, where organisations rely heavily on EU nationals to fill both playing and support staff functions. Organisations need to consider their existing workforce, but also look ahead to a new regime which may involve them having to sponsor EU nationals in accordance with quite onerous requirements which will carry significant barriers to entry, as well as costs and administrative burden. Despite continuing uncertainty over Brexit, the position regarding the rights of EU and EEA nationals to continue to live and work in the UK is clear and has been for some time now. As a result, organisations are in a position to communicate with their existing EU population about what they need to be doing to secure their status in the UK, as well as any UK nationals who may be working in an EU or EEA member state. We also have a reasonable idea of how the immigration landscape may look when a new regime is introduced, probably in January 2021. In this webinar, we're going to provide you with a brief update on the very latest Brexit developments, as at the 22nd of October 2019, before focusing specifically on immigration and right to work issues, and how deal or no deal may affect the position. We'll cover off the recently launched EU settlement scheme, and look ahead to what a new immigration regime may look like. The session is focused on the right to work in the UK and across the EU, but we'll also touch briefly on how Brexit might affect general travel arrangements for sportspersons, administrators and spectators, both in and out of the UK and across the EU. So in terms of the very latest developments, well, as things stand, the UK is still set to leave the EU on the 31st of October 2019, but we still don't know the terms on which it shall be leaving. The government has agreed a deal with the EU, and on 19th of October, Parliament voted to withhold approval of that deal until it's actually been passed into law. A couple of days later, the Commons Speaker refused a request by government for there to be a simple yes or no vote on the deal. As a result, there will be no vote taking place until the withdrawal agreement bill has been passed into law. If government can't get that bill through Parliament, the default legal position is for the UK to leave without a deal on the 31st of October. But that could change if the EU grants an extension until 31st of January 2020, per the unsigned request which Boris Johnson was required by law to send to the EU on the 19th of October. We await their response, and they may well grant that request, they may refuse that request, or they may come back with an offer of a shorter or a longer deadline as an alternative to the 31st of January 2020. Despite that general confusion and uncertainty regarding the date of leaving and the substance of any deal, if any, the immigration position for EU nationals already exercising treaty rights in the UK is clear. The headline is that free movement of people is ultimately going to come to an end if the UK does indeed leave the EU. However, those EU and EEA nationals or their family members who are in the UK before the relevant cut-off date are able and will be able to regularise their status in the UK by making an application under the new EU settlement scheme. The key question and the outstanding question is, what's the relevant cut-off date? Well, that depends on whether the UK leaves with a deal or without a deal. If we leave with a deal, there would then be a transition period during which EU law would continue to apply. If the UK leaves without a deal, there would be no transition period, and the rights of EU nationals in the UK would then be subject to UK law. If we look at the deal scenario first, as I said, free movement is going to continue during that transition period, most likely until 31st of December 2020. All EU, EEA, Swiss nationals and their family members who are in the UK prior to the end of December 2020 are able to apply for either settled status or pre-settled status. The deadline for those applications is likely to be the end of June 2021, and reciprocal arrangements will apply to UK nationals living in other EU member states who would continue to be subject to the principle of EU free movement. If we look at a no-deal scenario, free movement under EU law would come to an end on the date that the UK leaves the EU, so the Brexit date, whether that's the 31st of October 2019, it might be the 31st of January 2020, it might be some date in between those two dates, or it might be some further date in the future. However, even though free movement under EU law would end on the date the UK leaves the EU, the UK government has said that there will be a principle of free movement under UK law that would continue to apply until December 2020. Furthermore, anyone entering before the Brexit date would be eligible for pre-settled or settled status. The deadline for making an application under the EU settlement scheme in those circumstances is likely to be the end of 2020 as opposed to at the end of June 2021 in a deal scenario. Anyone entering the UK after the Brexit date will still do so freely under UK law, but they will be required to register for a new EU temporary leave to remain status. Furthermore, their position from 2021 onwards is currently unclear. In particular, we don't know whether that temporary leave to remain status would give them a route to settlement. We suspect not. It's more likely that they would then become subject to whatever new regime is going to be introduced. UK nationals who are in the European Union, in the event of a no deal, will need to keep a close eye on developments, and that's because they may well become subject to new immigration requirements and restrictions sooner than anticipated. One further point which could be relevant, regardless of whether or not an EU national has been able to get pre-settled or settled status, is that restrictions on overseas sports persons may need to be reviewed, as the rulings arising from the Bosman and Kolpak cases could cease to apply in the event of a no-deal scenario without a transition period. The rights of your existing workforce to live and work in the UK is therefore not going to be particularly affected. However, they are still going to need to do something to regularise their status, and they'll do that by making an application under the recently launched EU settlement scheme. That is going to be necessary even if they've previously gone to the trouble of getting residence or permanent residence under the old regime. Those who've been in the UK for 5 years or more will be eligible to apply for settled status, so it will give them a degree of permanence in the UK and as a precursor to ultimately applying for citizenship if that's what they wanted to do. Those who've been in the UK for less than 5 years will be able to apply for what's going to be, or what is referred to as pre-settled status. Pre-settled status would then give them a path to settlement after 5 years. The deadline for obtaining pre-settled or settled status is likely to depend on whether we have a deal or we don't have a deal. 30th of June 2021 if we have a deal, end of December 2020 if we have no deal. Organisations are going to need to keep track of which of its workers need to make an application and when those applications have been made, and that will become particularly important as we come closer to the cut-off date for obtaining the necessary status. The good news is that it is an extremely straightforward process with very basic eligibility criteria. Essentially, you need to be an EU national, or an EEA national, or a Swiss national, or a third national family member of one of those. In order to show that you fall into that category or those categories, you would submit your passport or ID card, and if you're relying on being a third national family member, you submit evidence of your proof of relationship. You would then need to show residence in the UK, and that is essentially done through tax records. If you're registered with HMRC to pay tax, then it's going to be very straightforward to show that you are eligible to apply for settled or pre-settled status. If there's been gaps in your tax payments, or for whatever reason you don't pay tax, then proof of address may well become important. As I said, the Home Office has made this as straightforward as possible, and in particular they've looked to introduce a very streamlined process. There are no clunky paper forms to deal with. Instead, you can simply download an app, and through that app you can upload a photo of your passport and then go through a basic online form. You enter your residence details and you provide your national insurance number, and the Home Office then use that to cross-check against your HMRC tax records. You then simply wait for a confirmation, and the processing times, certainly to date, have been extremely quick, with most applicants getting a decision within around 48 to 72 hours. This process is free of charge. There is no application fee for either pre-settled or settled status. What about the future? What does the future hold once any transition period comes to an end, or in the event of no deal, once we get past the end of 2020? Well, the government has made it very clear that it intends to introduce a new immigration regime covering EU nationals from the beginning of 2021. Following proposals by the Migration Advisory Committee, that's MAC, which were accepted by Theresa May's government, we do have a rough idea of what that new regime may look like, although it should be noted that Boris Johnson has subsequently asked MAC to engage in further consultation and submit proposals for what he describes as an Australian-style points-based immigration system by the beginning of 2020. The headline from proposals to date, however, is that EU nationals are not going to be given preferential immigration treatment, and so they're going to be subject to the same or similar criteria which currently apply to non-EU nationals. This will either involve obtaining some form of temporary visa, which allows work for short or fixed periods, or the EU national will need to be sponsored by a UK employer. This is going to impact organisations and job types differently. MAC has suggested a softening of the current sponsorship criteria, but there will still be many roles which fall short of the fairly onerous skills and salary thresholds. Even if the roles do meet the criteria, organisations are going to have to deal with the cost, complexity and administrative burden which comes with the sponsorship system. As things stand, an organisation would either be looking at some sort of short-term youth mobility visa option which allows work, or sponsorship under Tier 2 or Tier 5 of the points-based system. Tier 2 has various subcategories, including one aimed specifically at sportspersons. A UK organisation would need to obtain a Tier 2 sportsperson sponsor licence and an endorsement from the relevant governing body. It would then be able to use that licence to sponsor sportspersons that meet the relevant criteria. And in particular, the sportsperson or coach would need to be internationally established at the highest level. There's also a general subcategory under Tier 2. Again, the UK organisation would need a sponsor licence, but it would only be able to sponsor a migrant worker if that worker met the relevant skills and salary thresholds. And as things stand, only after having tested the local labour market to check that a settled person, a local hire, couldn't fill the role. An alternative option, which is quicker and cheaper, might be the Tier 5 creative and sports persons route, but that is temporary in nature. It only allows someone to come into the UK for up to 12 months, and if it's under the sports person subcategory, that person would still need to be internationally established or in a position to make a significant contribution to the development of sport in the UK. I've just included here a high-level comparison of the EU and non-EU regimes as things currently stand. And as you'll see, engaging EU nationals in the UK is set to become a lot more difficult and expensive if, as we expect, they're treated or they are to be treated in the same way as non-EU nationals. Of course, in many cases, sports persons, coaches, administrators, spectators, etc., will be required to travel overseas to a variety of countries across the EU, or indeed come from the EU into the UK, without actually engaging in work within the relevant country. If there's a deal, existing arrangements will continue during the transition period, and so no issue in terms of UK nationals travelling to EU member states. If there's no deal, restrictions may take effect sooner than anticipated, and UK nationals could become subject to visitor rules which limit the time they can spend in an EU country and the activities which they can undertake. Suggestions from the EU are that they would be able to spend up to 90 days in any 180-day period in countries which fall within the Schengen area. Non-Schengen countries within the EU would have their own rules. As a result, it's going to be crucial to plan ahead and assess which trips fall within the visitor rules and which may require advanced visa clearance or a visa which allows work. In all cases, you're going to need to analyse the duration, the frequency and the purpose of trips to determine whether the activities are permissible as a visitor or if some form of work visa will be required. This could well vary from one EU country to the next. In terms of other practical tips, certainly in the aftermath of a no-deal Brexit, the Home Office is advising that if you are travelling to the EU, you have a passport which has at least 6 months left to run on it, and that it's no more than 10 years old. Other things that you might need to look at would be your travel insurance. Are you sufficiently covered because your European health insurance card may no longer be valid? The same applies to driving licence. In the event of a no deal, it's likely that an international driving permit would be required. And then finally, but on a similar theme, what about post-Brexit travel into the UK? Well, there's no issue if there's a deal. As we've said before, the current position would be maintained during a transition period. And even if there's no deal, the government has said that free movement would continue under UK law until the end of 2020. However, from 2021, it's going to become particularly important to assess whether or not a trip will fall under the UK visitor rules or if the activities will constitute work and therefore be caught by the new work visa system that's going to be applicable to EU nationals. That will involve planning trips well in advance and careful analysis again of the purpose, frequency and duration of the visit, as well as consideration of who is going to be paying the person. Will they be paid from the UK or from overseas? If the activities are not permissible as a visitor, a visa which allows work would be required. So in summary, lots of changes to our immigration rules ahead. And despite there still being a lot of unknowns surrounding the basis on which the UK will leave the EU, the immigration position is sufficiently clear for organisations to be reviewing their existing right to work and overseas travel arrangements and processes, as well as for them to start preparing a strategy which will take account of the significant regime changes expected from January 2021.